Do a payment? Yeah, third. They're closed. I'll just do it online. Oh, Tuesday. Do you know if the collection agency's open? Collection agency? That's not agency.
finish up down there?
Is there envelopes over there? Oh, this is, oh, cool.
That's it right there.
Got an online report to watch state court rules. Of course, the administration has watched Washington Bar Association with the volume state of 2020 and the 2019 for the physical period of inquiry of April, which is a tax return, and also the March would be the presidential election campaign. Presidential election ballot forms are filled by the Secretary of YVONE, but the rules of distributing and applicants on rules of professional conduct are in process because of the administration office has this preface of court rules, and they have the associate material governed by the practice of West State court rules, placing year after year in that edition to affect it and also to upgrade it and perfect it in many ways in amendments, as we have the amendments here. Every amendment to statute is by Barela. Every statute amendment to service is Barela, because for the effect of the amendment on the 540 preface below service as the appendix volume, and the issuance of the year and the date of the month and the physical year. There is the reason for this amendment to make the nurse substitute to clarifying these damages, because the damage on this is a retroactive application. Retroactive application on the amendment means reduces the guideline range or reduction on the concurrent sentence or consecutive sentence, because that amendment provides exercising discretion on reducing term imprisonment, incarcerating defendants of the court who reduce their term in imprisonment below it for serve on that defeated grant greater reduction in imprisonment and imprisonment time remaining to be served for that affidavit, because the live virus, the SARS-CoV-19, that's administered in all the Andy Miller's servers, desktops, towers, i3s, i5s, i7 laptops, and also the effective federal guideline, manual watch state court line and guidelines. The preface and bull letter has amendments received through the services from August on from 2/19/220, and effective dates from the contact, and that's the reference attorney's contact. Reference attorney number 1-800-733-2889. Contacts West Additional Department certified directly from the question of service. Email West Editor at Thompson Rotor, and that's Thompson.com. Those Thompson Rotor emblems are all over the ISBN, the SID numbers, the FBI numbers, and also your credit card swipe and your credit card and your security code, your 3 initial security codes in the back, and also your increments and your first and last name in the front, and also the occurrence of the effective date. Limited practices, and also the commission rules and limited jurisdiction rules on the table of contents. They also have the moderated, of course, the Gorilla Glass. This Gorilla Glass is not retroeffective. It's active, as you can see. This active Gorilla Glass here is probably the best Gorilla Glass you can get for 100 pennies. 100 pennies equals $1. At that time and date, for 14 years ago, that'd be Mr. Obama Medicare, and their service for taking the Gorilla Glass and the Verizon equipment, the 7, which exploded for Verizon equipment, exploded, and all customer and clients and business owners, all business owners are pretty much all business owners, and exploded. Thompson Reuters ProView, the title of one may have available on the tablet on ebook. Take this reach mobile, powered by Thompson Reuters Pro app, and ebooks deliver the same trusted content of the print resources on compact to go format. So this Gorilla Glass is $1, 100 pennies. So those 70 pennies, and it leaves you 30 pennies of the dollar. So they tax you on top of the 70 cents onto each dollar. That's a lot of Gorilla Glass. ProView books are designed for the way work. You added your own notes, highlights to the text, and all notion traffic electronic every edition. This is receipts and transactions is perfected, and the general rules of GR, Code of Judicial Conduct, and also the Board of Judicial Administrative Rules, Rules of Professional Conduct, the Mission, Practice, and Rules of Mission and Certificate of Limitation Practice, LPR, Rules of Lawyer Discipline, RLD, and all the Rules of Enforcement of Lawyers' Conduct, Judicial Information System Commit Rules, Washington Rules and Evidence, Index Rules and Evidence. The Washington State seals are permanent. There's no prying on it. There's no trying to catch it on fire. There's no inserting or trying to get rid of it. And this document's old and prefaced, and it's served, and it's been paid for in full. And the rules on applicant rules, Administrative Supreme Court Administrative SAR, Court of Appeal Administrative Rules, Supreme Court Appeal Administrative Rules, Index Part 2, Rules of Appeal, Rules of Appellate Procedure, RAP, Appendix of Forms, and Index of Part 3. Parts of Service Superior Court from A to F here, 7112 Okanagan Place, says Kennel Watch 9933, Annie Miller's office. That's 509-735-3591, which is facts and evidence and equipment that is used for the mission and practice of rules and the fitness and board. There's a requirement on this recommendation, restraints on recommended chapter of fitness board only on showing support by clear and convicting evidence and petitioner possession qualification meets requirements of reinstatement of the fourth of the rules that are petitioner that's rehabited. People that can pass their physical, run long distances, swim, and also power lift or sway and butterfly stroke and sway in their, of course, the doggy pedal, the doggy pedal, or the butterfly stroke front or back stroke. This action factor is a fitness board. This effective date is January, and this also rule effective until January. And this factor, considering characters and fitness of a board, the petitioner character's standing professional repetition in the community which the petitioner reside in character prior to disbarment, the ethical standard and petitioner observe in practice of law, the nature of practice, conduct, and the petitioner and disbarred. As you know, the 45 and 50-pound bars are bowed and bent because of so many repetitions. The sufficiency of punishment undergone on the connection, therefore making or failure to make in restitution are required. Petitioner attitude and conduct and reinforcement subsequent and disbarment, applicable in services not talking or individually tampering with these Washington state ordinances or using malpractice services, natural disaster acts or announcements to confront the petitioner attitude and conduct and reformers, making as some way of starting a confrontation in any way, shape, or form. These petitioners has a time that elapsed since disbarment. The time of elapsed disbarment, the petitioner's recurrence of prison in law, certainly freakiness, and the freakiness is strength, the freakiness, truthless of the natural strength of the blood supply that they were blood supply that they have to provide services for, and the blood intake services, what tenements or any tenements or whatever kind of attributes are in the blood system. The petition currency proficiency in law. This is sincerely frankness, truthfulness, and petitioners are proceeding discussing the factors relating petitioner disbarment and the reinstatement. Factors that consider in character and fitness in board. Following factors not be considered in evidence of petition characters of fitness, and the action of board recommendations. The character and fitness board shall be served upon petition pursuit. 20.5. Board recommendation statement record recommendation is transmitted to Supreme Court for disposition. The board recommendation against reinstatement record recommendations and retain the office of the Bar Association unless petitioner's request submitted to the disciplinary board and filling in the clerk of the disciplinary board a request of disciplinary board with 15 days of service recommendation of the character of the fitness board. The petitioner request the board recommendation shall be transmitted to the disciplinary board disposition review conducted under disciplinary rule 11.9, 11.12, the rules of enforcement of lawyer conduct. Petitioner does not request the record of recommendation shall retain and on reports or in records of the Bar Association petitioner shall still reasonable for payment or cost and so as to reinstatement considered directly and characteristic in the fitness board. Action on disciplinary board recommendations. Disciplinary board shall reserve in petitioner and also the board recommendation reinstatements and recommendation and transmit Supreme Court for disposition of disciplinary board's recommendation and reinstates the records recommendations shall retain the office of the Bar Association unless the petitioner request is submitted to the Supreme Court by filling in the clerk disciplinary board request Supreme Court review within the 30 days service recommendations. Petitioner request and the recommendations shall be transmitted to Supreme Court for this disposition. If the recommendation shall retain the records to the Bar Association, retention is still responsible payment, cost and incidental reinstatement and proceeding direct disciplinary board procedure rule 13.9 rules for the enforcement of lawyer conduct, formerly 21.5 adopted effective October 2002, renumbered at APR 25.5, amended effective December 1st, 2006, amended effective January 1st, 2014. Action Supreme Court determination. The text of effect of January 1st and also effective January 1st. Petition approved and the petitioner reinstatement approved Supreme Court reinstatement shall the petitioner take the passing, examining, banging, the bar exam, membership fee and current fee, paying costs, and additional reinstatement procedure determined Supreme Court. And this petition is denied, the petition reinstatement denied, and examined shall be refunded and petition. Say the service and increments in first and last, and also the surgeon and also the doctor's signature and services be pretty effective and proactive. This is predominantly a push and shove a max over the provisions on legal services, pretty much a determinant of a major disaster, as they call the Washington following major disaster in Washington, temporary practice in Washington following major disaster in jurisdictions, duration of authority, temporary practice, and court appearances, disciplinary authority, and registration requirements and approval. professional conduct, to the provider rule 8.5 and rule of professional conduct. These clients and lawyers licensed practice law or in other United States jurisdictions who provide legal service with their rule informed client Washington jurisdiction. They license practice law and limits and license, and they are authorized to practice law in Washington except are permitted by this rule. They should not take the implied person that they are authorized licensed practice law in Washington. Limited practice rules for limited licensed legal technicians. See, these purposes and civil legal duties from their service commission of the Supreme Court clearly established the legal needs for consuming public and currently being met. Public entitled and insured and legal service and rendered only qualified, and these qualified trained legal practitioners, only legal professions authorized to provide such services and purpose of these authorized certain persons. Limited legal assistance advice approved practice areas of law. This rule shall prescribe conditions and limitation upon provisions such services under protect the public of the insured. Only trained and qualified legal practitioners may provide the same. For the purpose of this rule, the following definitions will apply. APR means Supreme Court admissions to practice rules. The board means the means limited licensed legal technician board. Number 3, lawyer mean person licensed eligible to practice law in the United States jurisdiction. Number 4, legal licensed legal technician LLT means the qualified education, training, work experience authorized to engage in limited practice law, approved practice area law, specified rules, retaining regulations. These legal technicians do not represent the clients of the court representing negotiation, provide limited legal assistance for the rule of pro se client. Number 5, paralegal legal assistant means person qualification, education, training, work experience, who is employed and retained by a lawyer, a law office, a corporation, government agency, or any of those entities who perform specific and delegate specific law-related work, which the lawyer is responsible. Number 6, reviewing and approved Washington lawyer means Washington lawyer personally supervised legal work and documents supervised by Washington lawyer's signature and bar number. Substantive law-related work means that he requires knowingly and constantly but necessarily performed by a lawyer. 8, supervised means the lawyer personally directs, approves, has responsible work before related license and legal technician. Washington lawyer means legal, and this means the person licensed, eligible for practice law Washington, who is active, married, and a member of Washington State Bar Association, words of authority. May be description to the right of permitted to. B, must be shall means required to. C, should means recommended but not required. License, and this limited license legal technician board established and therefore established and limited license legal technician board. The board shall consist of 13 members appointed to the Supreme Court, State Washington. 9 of them shall be active Washington lawyers. 4 of them shall be non-lawyer Washington residents, and the 1 member shall legal educator. The members shall initially appoint staggered, and this is staggered terms. 1 of 3 years, therefore, appoint shall their 3 years. The members have served 2 consecutive full 3-year terms. Number 2, board responsibilities. The board shall be responsible for the following: recommend the practice area law for LLTs, subject to approved Supreme Court, processing application fees, screening applicants, and administering exam inquired under the rules shall minimum cover of the rules of professional conduct applicable limited license legal technicians rules relating to the client privilege and the subset of law issues related to the more improved practice areas. The term LLT, continuing legal education LLT, requirements approval of LLT programs. E, proving education experience requirements, license approved practice areas. Establish overseas communities and tenure of members. Establish collective examination fees, LLT, fees, annual license fees. Fees in such amounts approved in the Supreme Court as necessary carry these duties once the board. Such other activities function as present provided rules regulation board and so on purpose and regulations for adoption in the Supreme Court. Establish procedure of grievance of disparity procedure. Establish trust account requirements and procedures. Establish rules John And this is the John Papa Murphy rule, affidavit established rules of professional ethical conduct. Upon provisions and rules, requirements, and application happen for licensed and limited licensed legal technicians shall: 1. Age, at least age 18. Moral character, fitness, practice. B. In good moral character, demonstrate fitness and practice, limited licensed legal technician. 3. Education, following education unless waived board through regulation as associate level degree or higher, 45 credits in curriculum instruction, paralegal studies, approved board instruction, ABA approved. In each practice areas and licensed instruction approved in practice and lead services, ABA approved, law section approved, and the board shall determine the key concepts. The California ordinance, the California State and California Sacramento, and San Francisco, and that's of course the tortilla flats, that'd be tortilla flats, and also Los Angeles, downtown Los Angeles, and Mexico, San Diego services. These areas of practice, the scope would apply on authorized limited licensed legal technicians rule and many shape and forms. Mr. Bill Gates have been established on domestic relations, appendix regulations, APR, unlimited licensed legal technician board, overseas, overnights and overseas, and also in the administration office, which would be in the all the common legal services that the Navy Department, because of a yacht parked in the Navy Department, and the Navy Department is in the Navy Department in the yacht section. And that yacht section downtown Olympia would be carried Secretary Kim Wayman, also administration office A131, and that's the obtaining the real facts, explaining the relevancy of some information in client, contacting phone records, immediate landlines, client applicable procedures including deadlines, documents must be filed docked or off docked or tied down by docked, anything at 20 feet or longer from the docked yacht, transported from, of course, the vehicle, the truck, the dually, pickup, the semi-truck, or any of that 20-foot long trailer, binded by 2 cords on the Class A and B and C license, specialized weapon lines, enhancement services for that scope of practice, authorized and limited practices. Informing this client applicable procedures or proper service and process of filling his legal documents. Again, these legal technicians certing or issuing within defined practice LLT license. The LLT shall provide the service required on the issuance of the form client. Client should seek service of a lawyer. And the issuance of on ground to ground, air to air, air to air to air, air to air, or ground to ground. This obtain relevant facts, explain relevancy of such information to the client. Select complete file effect service of forms have been approved in the state of Washington, either through governmental agency and administrative office, courts of contempt, which specifies statutes, federal forms prepared by a Washington lawyer, forms approved at the board, advised client significant and selected forms client case. Perform legal research on draft letters and pleadings documents beyond permitted. Advice to the client other documents may be a necessary client case. Explain how such additional documents and pleas may affect the client case. Conditions under the limited license legal technician may provide services. Limited license legal technicians might have principal place in business having physical street address and adequate service process in the state of Washington. The limited license technician must be personally perform authorized service to clients and rather dug into those non-licensed person. Nothing prohibited on prevent person is licensed LLT for performing translation services. Prior performance and service and fee, limited license legal technician into the written contract and the client signed to a client. The limited license legal technician includes following provisions. Explain the services to perform, including conspicuous statements that limited license and technician appear on levy present client administrative and formal disputes resolution process negotiating clients' rights responsible unless permitted under ground rule 24B. Notification for the fees and costs to charge clients of service reform. States upon a client's request, an LLT shall provide the client documents submitted to client's limited license. Regulations of the Limited License Legal Taxation Board General. Every person desiring license, maintain license, and also licensed technician LLC pursue administrative practice rule APR. Like we said, APR rate in Collective 28 shall satisfy requirement APR 20 and Appendix APR 20. Facilitate prompt administration APR 28. Regularly designing and designated staff of Washington State Bar Association, the Washington Bar Association may act on behalf of the LIT Board at APR 28 their regulations. Practice areas, scope, practice others, limited license, legal technician rule, which is practice LLT license, LT compliant provision defined scope, practice found in APR 28 described herein. Issues beyond scope of like practice LT from due APR 28 if clients with issue arise beyond authorized scope LT when they emerge under APR 28F arise. The issue exists to describe general terms nature of issuance. LT authorized advise assist on issue. The failure to obtain lawyer's advice could be adverse in client's interest. Clients should consult lawyer and obtain appropriate advice and advice documents necessary to protect clients. So that sealed document's already done and sealed with. All it is wasting time and time and money. So they're asking for this and ask for that, and then doesn't make no sense at all. The decision of hearing of the domination title sanctions and remedies. The rules, sanction and remedies, also the effective date of the date of suspensions of disbarments. The suspension of disbarments are effective on the date of Supreme Court ordered on opinion, which ordinarily 7 days after the date of order. The date of suspension of disbarment effective 7 days after the date, and also when the terms of suspension when on the 7th day, God rose from the grave, and he had disciples because the individuals enlisted themselves in incurments of approaching on their terms and suspense. I think it will sink in for Rule 13 suspension. After this period of suspension, association administrators return suspension respondents to the law, and in respondent of statute before suspension with the rather order of the court upon respondents' compliance with all current license requirements, and also disciplinary counsel. Certifications to the respondent compliant and specific condones. Orders on paid and cost restitution, order incurring costs and restitution payment plan. The respondent may ask the chair to review or determine if relief counsel regarding compliance conditions, reinstatements, payment costs, restitution pay in full. A review of the chair may be modified in terms and payments or plan is warranted. And chair, or you can call the administration office, go upstairs, downstairs, the basement, and feed him everything that you got from the C-17 into his mouth, into his esophagus, down 1 hour duration. He'll sit his duration and re-pyramid and reformat the murder scene from his plain perspective of his concurrence of his service, of his notice repairing and repyramiding the order of imposing the remand final association council prepares a remade together to hearing officers finding conclusion recommendation opinions and board conclusions with the service of course that document which is sealed and can't be always tampered with and attitude or put white out on it, fabrications of the cost expenses and the of course that document the achievement of the cost of expenses, and also rules during application and assessment matters reviewed by the court, and also the payment costs expenses is a waste of taxpayers' money, and also the state and fed department, and also the FBI CI department, and experiencing their services for the increments for that blood results, which is all negative, but all the adversaries that are covered with the disguised Rule 13.5 and the disguised Rule 13.6 and the Rule 13.5 and 13.4 because the increments on their services on costs, the services are paid, and they're all considered as Washington Rules of Evidence in ER, effective April 2nd, 1979, including amendments received through August 15, 2013. This general provision, scope, purpose, and construction ruling evidence, primarily question, limited administrative reminder of related writing and recording statements, charges and notice, and also the presumption of general civil action proceedings and applicable state law of civil action proceedings, and also relevancy of its limits. Definition of relevance evidence, relevance of generally admissible or irrelevant evidence admissible. Exclusion of relevant evidence grounds and prejudice and confusion or waste of time. Now, this relevance of time is waste of time, confusion, grounds of prejudice, and exclusion of relevant evidence and grounds of prejudice and confusion and waste of time. Character evidence not applicable to prove conduct, exception other crimes. Methods of proving character. Habit, routine, practice, subsequent remedies and measurements, comprise and offers and comprise payments and medical and similar expenses, instrument pleas and offers and pleas related statements, liability insurance, and also these attorney-client privilege work product limitation waivers, and also the general contemptcy, lack of personal knowledge, oath, infirmary, interpreters, and also competency of judge, witness, competency of jury of witness, and who may impeach, evidence of character and conduct witness, impeach and evidence of conduct of crime, religious beliefs, and also the opinions, mode and order and integration and presentation, right of unseated, refresh memory, and prior statements of witnesses calling integration witness by court. Also the opinions and expert testimony, which falls on malicious rules, applicable rules, amendment rules, and title. These testimony lay witnesses, testimony and experts, basis opinion and testimony by experts, court appointed. Hearsay rules, hearsay exempt available declarations, and also the hearsay exempt declaration unavailable, hearsay within hearsay, attacking or supporting credibility of declarations, child victim and witnesses, requirement authorized identifications, self-authentication, and this self-authentication. This is official original describing witnesses, admissible documents, requirements, admissible, and also other evidence and content, public records as well. This is Washington Rules of Evidence, ER, originally effective April 2nd, 1917, including amendments received through August 15th. Introduction comment from 1979. Jurisdictions, Arizona. Jurisdictions, Arizona. Jurisdiction, Arkansas. Jurisdictions, California. Jurisdiction, Colorado. Jurisdiction, Delaware and Florida. Hawaii, Iowa, Kansas, Kentucky, Maine, Michigan, Minnesota, Mississippi, Montana, Nebraska, Nevada, New Jersey, New Mexico, North Carolina, North Dakota, Ohio, Oklahoma, Oregon, South Dakota, Tennessee, Texas, Utah, Vermont, Virgin Islands, Washington, Wisconsin, and Wyoming. Statutory citation for effective law of the USS services for the statutory citation 17A ARS Rules, Evidence Rules 101-110 through Arizona. Arizona, U.S. Arkansas, 1987, number 879, ACA 1641101, California, West, and that's SAS, Los Angeles, nuclear war class, West Cal Evidence Cloud 121605, Colorado, USS Colorado, nuclear war and submerged service air to air, long distance services, which is West CRSA. Tri-Title 13 App, Evidence 101 to 1102, Delaware, USS Florida, 7.1 1980, DRE 101 to 1103, Florida 71 1970, West FSA 90.101 to 90.958, Hawaii, USS Compromise, US Enterprise, and also the HRS 6261. Hawaii Rules Evidence Rules 100 to 1102 to 626-3. The Iowa Beef. The Iowa Compromise is 7.1 1983. Iowa Beef Slaughter Floor 10,000 kills, an additional 4,000 kills. That's 15,000 kills, 7 days a week, including Sundays and Saturdays, extra overtime. Iowa R AVID evidence rule 5.101 to 5.10103 slaughter floor, cannonballs, and also the gut table. Services for the hide peeled off the skin, put in the basement, also the eyeballs for surgical floor for insulin. This is for pharmaceutical and also active insulin that's injected for high agencies for disbarring hands, fingers, for gone green for evidence for diabetics. Now this is the USS Kansas. Kansas is KSA 660.401 to 60-472. Kentucky 1990 C88 supplement citation 71-1992 KRE 101 to 1104. USS Maine 22-1970 with the archive system with first and last administrations of the corresponding rules of evidence, rules 101 to 1102. USS Michigan 3-1-1970 Wolverine State, rules of evidence, rule 101 to 1102. Minnesota, many lakes, 1,000 lakes, million lakes, billion lakes, millions lakes stakes. USS Minnesota, battleship 7-1-1977, 50 MSA evidence, rule 101 to 1101. USS Mississippi, look your ordnance and services for supplemented ordnance citation order 9-24-1985, MRE, the 101st to 1103 bracket, and this administration, George Washington administration leeway, George Washington House, and path to all ordnance administration office with the path of Mrs. and Mrs. Mansfield, USS Montana, Mrs. Patty Murray's Cantwell Senator's office, and also the all senators that have been compromised and conversated on their recall on their email address for their ballot form for presidential prime election for Washington State. 71977 rules of evidence, all of them have been evaluated, conversated with, recited information to on the digital conference information of all senators, including Senator Perry Marion Cantwell, on guidance system and services of Mrs. Vach Mugans and Donald Trump. USS Nebraska. Ordinance of law is 12-729-1975 LP 279. USS Nebraska compromise in their service for increments effective date 8-24-1975. Beautiful machinery factory that produced all archives for nuclear ordinances, all tanks, Abram tanks, Apaches, Hercules, Chinook C-17s, and also the A-10 nuclear combated override system, which is used as a stationary citation, which is 108, RIS 1943, 27-101, 101st to 27-1301, and that's USS Nevada, 971 C-75 at NRS 47.0202 52.295. And New Jersey, U.S. New Jersey supplement for the jerseys and the cattle and the heifers for the dairy products and the silage compound service in Nebraska, USS Nevada, and USS New Mexico, and U.S. North Carolina, North Dakota, and Ohio, and Oklahoma, and Oregon, South Dakota, Tennessee, Texas, Utah, Vermont, Virgin Islands, Washington, Wisconsin, and Wyoming, the cheese state, and also the cowboy state, the all-stars, you can see Wyoming. This Oklamon's and Mr. Tim McVeigh, nothing but a Unabomber, coward, covenant individual, just like the services they have for the Unabomber terrorists and Al-Qaeda, ISIL, the Taliban members, and the PISAs in the state of California. And then St. Louis and Ronald Reagan administration is paid in full, as you can see, the Red Lion and services on Facebook and YouTube and administration office. USS Nevada 1971 C-75 NRS 47.02 to 52.295. USS New Jersey supplemented for the dairy product solids and components and service supply citation Order 9-15-1992. That is 7-1-1993. And that's the citation, and that's the stationary bicycle for contractor and services for the Cadillac program for the update Ironman competition. What's the services for the golden and also the silver and bronze, and Mrs. Phelps laying on my couch at Gazette, sponsored by Walker's Furniture and Equipment Devices, transported at City Hall in Othello, and also the insurance company Safeco Insurance. Back in the 60s or 1900, 1800, it's called Safeco. And Mr. Jim Logan, and also Jim Logan Services, providing his table to the community, or his buildings to the community, which is Studio 7, and also their compound facility, canvasser program, which didn't work out for him because Andy Mill got the UBI number effectively to that date. So U.S. New Jersey supplemental citation orders 9/15/1992, effective date 7/1/1993, July 1st, 1993, NJRE 101st to 1103, New Mexico 1973, South Sea Order, and that Seabird Sea Order ordinance of drone predator, and also increments of the Global Hawk 7, that's July 1st, 1973. MARA Rules of Evidence, Rules 11, 101st to 1102, North Carolina, and also the North Carolina is South Carolina, North Carolina, South Carolina, the Dreamliner Boeing 747, which is an update for the upgrade Air Force One, Nebraska, USS Nebraska, Nevada, New Jersey, New Mexico, North Carolina, North Carolina, North Dakota, Ohio, Oklahoma, Oregon, South Dakota, Tennessee, Texas, Utah, Vermont, Virgin Islands, Washington, Wisconsin, Wyoming. 1/1/1978, effective date. Rules of Evidence, Rule 101st to 1104, Wisconsin Supplement Sentencing Order 5/9 with Complemental Ordinance on Supply. Rules of Evidence, threatening, banishing weapons, any conversation on devices, wireless devices, or laptops, and evidence of a Colorado 101st Airborne or 82nd Airborne. The compromise of weapons or enhancement weapons or intimidation by mouth or by tongue or by finger, evidence with laptop or devices, or increments of evidence in a facility or household service. Evidence is Nebraska, USS Nebraska, 1978 LB 279-824, U.S. Evidence, South Dakota, U.S. South Dakota, which prevailing wage and services, and also hourly wage, and the Temple of South Dakota is STCL 19-9-1 to 1918-9. Now 1918, the Blue Bridge was built, and Kennewick, Washington, was CHIP, and also their Cannon homeboys and sassy evidence of no black minorities or Mexicans or Jews or any selective services and Social Security office coming in the store or Tri-City Herald or coming to the base in Bodacious Rodeo, discrepancy with none of my approval, of course, because I got 911 dispatch right here. You call 911, and there's somebody crossing through the highway into my plantation, and they're gonna have to smash your head into the apple orchard and drain all the apple juice out of your earlobe, because the earlobe don't belong to the device, don't belong to you. The gold mine, the coal mine, the liquor shaft, the strawberry fest, the pears, the pecans, the squirrels, black panther kitties, my pet blacker kitties, and also the peckerwoods, and also the fragrance administration of the liquor equipment, of course, with Mr. Footprints of Mr. John F. Kennedy and Mr. Kennedy coming to 1313 West Grand Line, talking to Bo Dason and Frost and the PBR, and having their sheriff posse administrative issue serving aliens left and right for pennies at a cent of that duration, where they're having that 13-14 recession with Obamacare. These are regulations and APR rates. Of course, this is Sandy Strong administration of prisoning Mr. Obama and F tank, G tank, H tank, A tank, B tank, C. These are felony, serious criminal murderers, transvestite individuals, as Mr. Andy Mo would say. The regulations in general, these persons and licensed and mandate literature of legalized technicians, LATT, pursuits administrative practice. See, they all, Mr. Yates and murder cases, and of course, these murder cases always say these individuals they don't care about you. They don't have nothing to care, because these technicians, these commutative license requirements, these domestic relationships with these ties and services you have, there's no attachments, there's no strings attached to these individuals, because Nebraska 19 seals right here in the document, rules of applications for interdiction. This is 1979, September 1st. And this continue on New Mexico and USS Wisconsin's G State. Supplement Citation Order 59, W2D, page R9, 1-1 WSA 901.012 911.02. 911 is the Porsche, the Boxer, the Corona Port Boxer car. That's the most best vehicle you can have in residence. You can pretty much take corners at 230 miles an hour easily. A sharp turn, it's like a 0-0. Actually, it's like a 0-0 turn on a lawnmower blade with multiple 3 blades, a 0-0 turn on it with pedal and turn. That's the Porsche. Is the probably most effective 0 to 60 miles an hour in 2.4 seconds. And the new turbocharged governor system with the Microsoft camera, you can overlook that in Bill Gates' estates online on Mr. Andy Miller at CO Benoit. It's online. The Wisconsin, USS Wisconsin, can WSA for the citations, WSA 901.012, 911.02. USS Washington, 4-2-1970, Rules of Evidence, Rules 101, 211. That's Mr. J. Mueller, Mr. J. Mueller himself, FBI, Air Force, Marines, Pentagon, services right there. Rules of Evidence, Rule 101, 211. Just dig right in and pull and reincarnate and weed that and put that little lawnmower blade on and you go around that headstone. You get busy on that. You confiscate for everything you did wrong to everybody you think of you did, burning your bridges down. So it's Virginia Islands right next. Step on up. Jump. They say you can jump as high as you want. Pretty much jump as high as you want. It says 5 VIC 7712956. The next one is Vermont. And that's 4-1-1983. Rules of Evidence, Rules 101 to 1103. You can jump on up. That's Utah, Brigham Young, Salt Lake City. And that's the air-to-air, and also the Amtrak Railroad, and also detachment for the cavalry and services for 9-1-1983. That's 1983. Rules of Evidence, Rules 101, 101st to 1103. Now you jump on Texas, USS Texas, 3-1-1998. Rules of Evidence, Rules 101st to 1009. USS Tennessee, 1-1-1990, Rules of Evidence, Rules 101st to 1108. Now USS South Dakota, SDCL 199, and that's 1919 is Blue Bridge, but it's 1918 with -9. See that you ain't going nowhere. You're not going to Sunset Ridge. You're not going to Oklahoma, Treasure Island. You're not going to Beverly Hills. You're going to stay in your area and make sure that your rules of evidence is compromised on, of course, online, right here on the spot. It says Rules of General Application on the ground and air-to-air, original effective July 1st, 1970, including amendments received through August 15th. And this is 2020, 2019, this is 2020, and this is April. And this classification system report rules, holidays, finding, hearing, time extends, service filing, and then so forth. Law librarian audit, session and course, local course, filing, effective dates, Supreme Court's rulemaking, ethical advisory committee, right, and opinions. And that would be, of course, we'll have family law, courthouse facility, mandatory continuing education, presiding judge, superior court, limited jurisdiction, and electronic filling access, court rules, court performance and audits and requests of persons, and the disabilities that request for the persons request waiving court clerk fees, CH charges civil matters and basis of indemnity. And there's no indemnities for the purchase of this individuals of this Washington federal guidelines because this is paid in full. Now, increments on these presumptions of civil actions and process, the Rule 301, presumption of general civil actions, proceeding reserved. Rule 302, applicable to state of law, civil actions and proceeding reserved. Remedies of its limits, but Rule 401, definition of relevant evidence, the relevant evidence, relevant evidence, real evidence, the means evidence of having tendency to make an evidence of the fact of its consequence of determined action where probable and less probable without evidence. Now, relevant evidence and generally admission what relevant evidence in middle school. So if you take a sharp, gigantic sickle and you use it as a weapon and it melts inside the orifice of the eye, that's called invincible evidence. What weapon could do that? There's no weapon, there's no weapon in possession, but it's an icicle. It is 30 below outside, so you walk in here with the icicle and you put it in the orifice and it says relevant evidence, generally visible and relevant evidence admissible. So the coroner is looking over, taking the individual to the side, and you notice it's relevant and admissible, and it's a principal requirement authorized by the statute of this rule. But if the porcupine quill in your hand is lodged and the porcupine quill is stuck in you, it is still stuck in you. But the sickle is melted away to H2O. So this is called relevant evidence of general relevance, evidence, admissible evidence. So that is a good example with 402 and 403. See, and very, very, very impressive. Exclusion of relevant evidence and grounds of prejudice, confusion of waste of time. That is a waste of time, pretty much an example of waste of time. Evidence may exclude appropriate value substantive outweighed by the danger of unfair practice, confusion of the issuance. Those porcupines are very distinctive, but the unactive porcupine quill will not spur at the moment, but the active spur, the dead quill spur, will not activate. But sometimes there is a nerve, central nerve cell connected to the porcupine quill. So you gotta let that porcupine sit for a duration of time because that nerve endings are still active. So if you take a live porcupine quill and stick it in the orifice of anybody, it's gonna sprout out, and when you pull it out, it's gonna pull veins, arteries, tendons, muscle tissues out of you, pretty much, at one stroke of motion. One stroke is like a serrated blade, basically. It's like a explosive air gas muscle APOM from well, it's like Agent Orange. It's like Agent Orange, or it's like anthrax. It's like tear gas. It's all at one time. You're through with, and you pull this 4013 rule, exclusion of relevance, and grounds of prejudice, confusion, or waste of time. Although relevant evidence may exclude probative value substantive outweighed by the danger of unfair prejudice, confusion, and issuance of misleading a jury, or consideration of undue delay, waste of time, or needless presentment of cumulative evidence. Rule 404, character evidence of non-admissible proved conduct, exceptions, other crimes. Character evidence generally evidence of person, character, trait, character, admissible, proving action and conformity, therefore character, accusation, accept. Character of accused. Evidence of proving character offered by accusation of by persecutor repute same. Character of witness. Evidence of proving trait. Character of victim of crime offered by accused by the prosecution of rebut the same evidence, character, trait of proof of witness. Now, the method of proving character. Repetition in cases where evidence of character, trait, character, admissible proof made testimony repetition of character that require allowable and relevant specification instance conduct. Case which character, trait, character, persons, and an essential element and charge. Claims, defense, proof also made specific instance of person's conduct. Now, Rule 4, the habit, routine, practice. Evidence of the habit of person routine practice, organized whether core body, or not regard this present eyewitnesses, rather improve the conduct of persons that organize per occasion and conformity of what habit and routine practice. Rule 407. Subsequent remindal measures. Measuring, you got meters, you got miles, you got fathoms. Of course they're in fathoms because you're in the water, and the ocean is fathoms. And you're going to go by fathoms, of course. You're going to go by mph, miles per hour. Acceleration by rate. You're going to go by ABS, by classification A and B, and also the container services are A, of course, CDL A and B, and those containers on either hazmat or discretionary and container-wise, or discretionary and the let's submit this one. It is it's a general knowledge, or the hazmat, or the school bus, or the passenger vehicle, or the air brakes, or the double triple, or the combination vehicles, or the tankers, or the preacher. So you got the air brakes would be one, because you're the most sophisticated individual. Love what the Apache and also the liquor ordinances onto the Stealth and on the Global Hawk and the Predator, and of course the drone that has assessment their services that court campaign, professional primary collection with your hands. This would be double, and the tankers would be one, the hazmat, of course, the general knowledge, or the school bus thing. ID and the administration obviously have to be around your neck at all times. Even if they tear around your neck and you have to go to the administration on Social Security, get a brand new one, or you want a license and show up with your, or of course go to the vault, in the bank vault, retrieve all your information out of the bank vault, and get all the information you need, your birth certificate, first name, last name, and come here to Andy Miller's office and have his death certificate and the death certificate filled out, and also death certificate and all the birth certificate filled out, all in one shot. It's called the hazmat. School bus, passenger vehicle, air brakes, double, triple, combination vehicles, tankers, and the air brakes would be one because they give you a 25 questionnaire on the air brake system. They give you the test way of how the vehicle low air pressure warning signal gauges. They ask for the engines off, step off brakes, pedal lower air pressure below 60 psi, or pump the brakes until the pressure drops below 30 psi, or pump the brakes while the vehicle is fully on. Or manually, you just back up and reverse with a Abram with the jet engines, and then correct yourself and just go about 0 to 60 straight into the building. And make sure you park it in Andy Miller's office with all the information down on liquor ABS services and liquor detainments and services and prints and services and blueprints to make sure this compromise a manual air brake system that has a single oncoming traffic modulator that's attached to it. It's like a periscope. It's a man-made periscope. Any left or right, any movement of your head or your shift of your left or right eye, your pupil, your anything you're looking at, it shows up on the information. It says, what is the test of your vehicle lower pressure warning signal? And it says manually air out brakes, or you consider your none. It would be the engine would be off and the brakes would pedal lower air pressure below 60 psi. Known for that reason because the rate of psi and rotation of the engine, of course diesel or unleaded, or you got jets on it, so you probably think it's aviation fuel. So you're looking for some weak points or throw something inside internally of the auger, the John Deere equipment, thinking that the RT wasn't going to run, the tank's going to run, or it might just eat it up and shoot it out, and then shows up on the global satellite systems that somebody is tampering with the John Deere equipment or the tank or the aviation cremator because the system says it's not registered in your first and last name and signature or a computer laptop system. It says air brake pressure is low. It says test way, the low pressure warning signal is turned off, leaving the electrical power on. The Vista Utilities, Ben PD, Mission PD, all services, all the English will show up on this step on or off the brake pedal. Low air pressure warning signal comes on or off, and then it would show up. That would be your answer. That would be a good answer because you're going to be a next one is going to give you an ABS question to it. It's going to give you what is true about the brake function of ABS, and they're going to go, how do you know about the ABS when it's not your ABS? Because it's not your transport. So it says, well, the C-17 says this has, no, it says the truck will slow down at that force. You'll have to pull over. Or are you going to pull over into the canines or into emergent traffic, or wait and call? Have the normal brake function, would have to call the ABS repair soon. There's some lights and headlamps and modular equipment known if it's ABS plugged into your system. You will also know the brake function in your prong, and that's a prong that has it says truck on it, and it says it will be in control or out of control, and it has vehicle and truck. There's two discrepancies on the ABS system. You can see it's on the logo. An ABS function of basic parts truck, it will have the brakes. I always have the ABS repaired as soon as possible, because there's no end of the day. It's only 24 hours or whatever that may be, 8 hour, 10 hour, 12 hour, 20, whatever that case may be. You just have it taken care of, because it's not going to break on you or nothing. It'll be fixed. It's guaranteed to use until the duration period. Pretty much, this is the next question. Will probably give you another ABS equipped question. This one will probably ask if your ABS is installed. Optional. They're going to give you some manufacturing dates. They're going to ask you probably what factory dates, like give you some answers: 1992, 1990, 1988, 2000, 2010. Everybody knows 1992. It says J. Mueller administration. The plaque says 1992, and everybody in the world knows what the administration says 1992 on it. The abstract run record says ABS is still optional, or you can check manufacturer dates, and those manufacturer, you can see it says logo 1990-92. There's no change in that. And that would be 1998, because it falls over 1990 and 1990 in the amendments we have here. This is the red portfolio of the federal guidelines, amendments, constitutional services that have been upgraded. But look at all these high peak turnover rates on the discrepancy on the cremator, because there's high peaks on the cremator for the global satellite, because with the durations of the human resources on the amendments that our statutes are effectively active. Now you got to check for the ABS system, check the vehicle and manufacture dates at all times. It says 1990, 92, and it's 1990, 92 is when it says 1998. So it's 1998, 1999. His emblem's right there. It's like, yeah, listen. The purpose, there's going to be more questions on the purpose of how to supply your press gauge. There's a press gauge, which is your pressure gauge. It's a press gauge. It says press or lift or a toggle, whatever the currency, what a manufacturer, Peterbilt, Freightliner, Volvo, or United States government, John Deere, Evergreen, John Deere, Molino. It says a toggle switch, print switch, a toggle switch, and that equipment you got is $15,000. But that new equipment, it is $15,000. Used equipment is $15,000. And if you want new equipment, it's still $15,000. And if you want it used, it's $15,000. So I would suggest that $15,000 goes for a brand new one, because any increments on that system, on your increments for voice recognition services, I would apply the brand new one, because there's nothing else to substitute for the purpose of supplying the pressure gauge. See, the auger carries out the system. The global satellite command chair close that system out, and they'll tell you how hot the air tank. It'll tell you how little the air tank holds, or I will tell you how much air in the tank at all. And then you're going to give you some trick question, all above, one of, or if yes or no, or yes or maybe. There's going to give some negatives and positives on this currency, but there's only one answer out of them all. And it is the air tank and how much air you got in your tank. You want to know what you got in your tank, period. Not currency negative, positive, maybe because of what of, could have, what of, or would have, or I should have curved, turned left or right, or merged in, or curved, or swing to you, or whatever the case might be at that weather, 4 seasons of that day. It'd be what you got in your air tank. Now, the relevancy of this time is definition of revelative evidence. Relevant evidence is also the admissible relevant evidence admissible. That's 402, 403, and 404. The evidence of admissible improved conduct exceptions other crimes. See, as I specified, in any information in which is all facts. Evidence of the person, character, or trait of this admissible purpose of proving action in conformity, therefore, particular occasion, except character of accused. Evidence of pretend of, let's say, you move a truck or vehicle out of your buttocks or off your stomach or off your skull, and then you get up and you pick it up and get up, and you required for the Washington State Collision Report and on person 7 days a week, because you're running straight to Seattle to the headquarters to let them know that the information that they have is not their face information. They don't own the land, and the character evidence is generally overlooked in many ways and shape and forms. So you can sit at the George Washington House where your mother and Mr. immediate family and your real mother and father live and provide their services. You can use this Rule 404 in character evidence not as will prove conduct is simple in other crimes. And they plead for their lives back to the fence line, as you can see. Character of accused, evidence of pursuit, and character of offered accused by the prosecution rebut the same. Character of the victims, evidence of pursuit, trait of character of the victims of crime offered by accused, or prosecution rebut the same. Or evidence character crime pursuable of the victims offered prosecution of homicide cases. To rebut evidence of victim, the first degree, second degree, and also regular homicide. We got all this online. This is Andy Miller at CO by Andy Miller's office, 7112 Okanagan Place, Kennel Watch 99336. Quinault, coming to Unite, QUIN, and they're digging into Quinault right now, and you're having all that Benton PD, Richland, Conwick, Pasco, Concord. Got pulling Nancy Pelosa's adversaries after this assessment. They're pulling Nancy Reagan, Mrs. Reagan, also the of course, the McCain family, and pulling them out, and all the services. They just drop him on the curb, just leave him for dead, just like Donald Trump and First and Mother and Lapson and their services and Bodation and PR. They don't give a crap about the administration of how their titles and relevancy and limitations occur. As you can see, it's pretty self-explanatory, and it follows on the method of proving character. Then the repetition of this case evidence and character trait, character of person evidence will proof made testimony repetition, cross-examination, allowed in retrospective instance conduct. Now the rule 408 comprise of office comprise. This is the civil case evidence. Furnishing Walker's furniture, furnishing all Walker's furniture, furnishing all your increments of promising you to furnish. Accepting, offering, promising, accepting valuable consideration, and compromising, tempting, compromising, claim which all disputed either. Or you can go to U-Haul truck and put it all in City Hall and put it all at the insurance company called 1918, and as you refer to all the increments of all the liquor classes and also the use classes and also the arrangements of the services, they're accepting, offering, and promising accept valuable consideration, and promising the attempting claim was disputed in these bounty amounts. And so will prove viability, having fingerprints, administration notes, all these desktops, laptops, services, business services, all the increments. You didn't pay him nothing for it. You didn't pay him a dime, pay him nothing for it. Just threats, intimidation, threats out of his mouth, in his mouth. I mean, you have to bring the agent straight to Andy Miller's office and leave him here. Leave them here to, and then you got these beautiful, original, down-to-earth individual people. They are, they usually call them Ku Klux Klan members, and they fully claim they have individual services. They have nothing but the truth. They're down to ground earth. They tell the truth, and being exposed in the public, try to see you're held as a jaundiced baby weighing 100 pounds with a intestine around my neck, hang off a tree. So when they cut that umbilical cord off around my neck, they pull the salvage and the intimidation of all the occurrence of the individual con artists, individuals, low-life, scumbags, and aliens, as you can see. 100 pounds and breaching to be nothing less but a newborn child. in the midst of Kennewick. Tri-Cities 1919 Blue Bridge. That's affirmative action in the Cable Bridge and Green Bridge. Look at your sailors, the sailor boys. Meltdown, the detainments and oil rigs, compounds and furnishing wheat farms and bays and barges. And of course you got these, of course, South Dakotans and just sticking up for the Navy Department because the Navy Department wants to sleep. The General NATO wants to sleep. Air Force Command and J. Mule wants to sleep. Andy Miller wants to sleep. All the generals and NATO arms wants to sleep. And then because the individual South Dakotans will just watch over all their shorelines, import-export service right there on the line. They love it. Increment the piece of the Tri-City Route in many ways, because that 408 promise, Rule 408 and 409, 4010, and it goes into civil case evidence, of course. He's furnishing their, it's called, and of course, the Chamber of Commerce. The book archive says bugs. These are bugs. Bug eater, bug. These are embedded in there, but this is what it is. It says acceptable of offering compromise, accepting beggar bugs, beggars. What did they are? See, valuable considerations. Attempting compromise of claim was disputed either value amount. Pulling the bug, the wasp or contaminant rodent out of and bagging it up in the bag and something and giving it to him, handing it to him into Andy Miller's office. Whatever it is, with blonde hair, wannabe blue, greenish, Jew eyes with the serpent-looking tongue that came out of its mouth, and all the members of the Ku Klux members are telling this individual he's a black, white minority, saying he's gonna do this or do that, and Jay Mueller with his pulling up in his cane and telling this individual, of course I'm gonna have to leave you here, Mr. What is your name again? Sean R. Logan? Mayor of Othello? Yeah, I'll walk from here. I'll walk all the way from LA, Los Angeles to Andy Miller. I'll walk whatever, Oakland, San Francisco, Beverly Hills. I'm not associated with familiars of anything current of you, my son. I walk. I'll go over here in Mississippi and sit in the military base and then do any CISA. You can do your thing and you fight your way out of it and burn your bridges, and maybe you can't have it go bait. Because this is evidence conduct. It's pretty familiar. You familiar with this one? You're at age 1, 2, 3, 4, 5, 6 at Cimaron 5 NC with all the Indians and Shiites and Saudi Arabians all at a king, downtown San Francisco subway. And I'm sitting there moderating and buying as much property I can, supplementing and depositing in Matt Miller's office. And there's nothing you can do about it because the preliminaries of your evidence on the conduct of statements made at concurrent negotiation and likewise admissible. The rules of the flames and the firing of the Chevron and also the Cimaron Gulf on flames, and all the siblings and children are just not confused, but knowing the evidence authorized discoverable merely because it presented to the court's compromise negotiations. The rules also require exclusion. That man called that white guy a negro, a nigget, own. They're all niggas. I gotta get out of here. Why you leaving me here? Because I don't associate with you. Because he's pointing you out. I gotta get out because what you are. Sorry, cannot talk to you anymore. No more. Not at all. Sorry. Wipe my hands of you. Pretty much. This rule also describes requiring exclusion of evidence, often or not for the purpose of proving the prejudice of witness, negotiating contention of undue delay, of proving effort, obstruct criminal investigation of prosecution. And this liability insurance with, of course, as agent, evidence this person was insured against liability and admissible upon issues whether person is negative, unauthorized, wrongful. This rule does require exclusion evidence of insurance against liability offering proposed preventing ownership or control by a prejudiced witness. And also, it will continue on to the opinions of the expert testimony. Get some ribeye, some pot roast, some marinated sauce, and have mushrooms and hot dogs and marshmallows and have barbecue right here, 1005 East Hamlet. And run billions of general population services. And I'll walk straight up into the administration office and have this opinion testimony by lay witnesses. Expert witness testimony from and the limited those opinion interference with any rationale basis perception of witnesses. We'll perfect when he'll give you a scope infrared to give you some prescribed glasses and a lethal charge of the shot, and it will vax a cure to you, and you will open your eyes up and see the real evidence in front of you. Understanding the witness testimony in fact issued on the basis of scientific, technical, or specialized knowledge with scope, Rule 702. And Rule 702, testimony by experts, scientific, technical, specialized knowledge will assist material fact understand evidence of determining the fact issue, a witness qualified as expert knowledge, skill, expertise, training, or education testimony, therefore form of opinion or otherwise. Now 703. You have to rep out with 703 in any shape, way, or form to be Rule 703. Even though you weigh 130 pounds, 100 pounds, 99 pounds, what's that guy going to do to me if I take him down and throw him up and skin him alive in public? Well, Rule 70 says basic opinion testimony by experts. It says the facts of data, particular case upon which any expert basis of opinion and inference made those of hearing. If the type reasonable relied upon by experts may feel forming opinions or interference of objects, facts of data need not visible in evidence. What's 704? Testimony in those forms of opinion. Mr. Brandon Lee and was very unsuccessful. Mr. Jet Lee and his siblings. Mr. Brandon Lee is very unsuccessful in that part. That's San Luis Obispo, California. But in Santa Barbara region and all the forefronts, it says opinion of ultimate issue. That guy has a death wish, and his services, it says 704. Testimony in that form of opinion and interference, otherwise invisible in objection, because of an embrace ultimate issue deciding by tier of fact. The fact. Now, how fast is fast, or how quick is quick? Hearsay substance available and decorate and maritime the specifications. Hearsay exceptions, decorate unavailable. Rule 804. You got to rep out with that, of course. An exemptive ruling in the court of ground privilege testifying concerning a subject matter, decorate statement, or persist in refusing testifying concerning simple matter declaration statement despite order of court to do so. Testifying the lack of memory of the subject matter decorate statements with those reps. Maybe you start realizing it'll sink in. Unable to present testify hearing because of death or existing physical and mental infirmities. Or absence. The next one. Absent of hearing a proponent statements. Or hearsay. Now we got the index. Now we got the rules of court. The Saturday court closes. Filing document extension of time. Ground Rule 3. Seals, court records, Ground Rule 15. Family law garnishment, Ground Rule 22. And they got the service. Desperate actions, this index. The mileage, the service, the upkeeping, the service, the mileage, or just all the footwork. All the footwork. Maybe just all footwork. There's no shortcuts. It's straight into your service demonstrate actions or signature electronic filling, pleading, and perhaps papers, attorneys, sound recordings, court proceedings, state bar association board commissions, meditation programs, privilege and immunities, missions and practice, desperate actions, and lawyer assistant program, meditation program, and purpose. Ground Rule 12.1, Ground Rule 12.2, APR 16, Ground Rule 12.3, Electronic ELC 12.2, APR 16, APR 19, GR 12.3, GR 12.2, APR 16, and GR 12.1, Statute of limitations, there it is, see? Disciplinary actions, ELC 1.4. Stipulations, disciplinary action, this index. Subpoenas, client protection fund, APR 15. Disciplinary action, this index. Sunday, court closed, GR2. Finding documents, extensions of time, GR3. And Supreme Court disciplinary action, ELC 2.1. Suspension of attorney, disciplinary actions, this index. Law schools, the law library. Holidays, GR4. Lawyers Assistant Program, generally APR 19. Lawyers Fund Client Protection, APR 15. Limitations of actions, disciplinary action, ELC 1.4. Limited license legal technicians, generally APR 28. There you go. You're live. That's probably about as real as you get. That's gaffling for that individual of how the real society of confronting Mr. Sean Logan in such a way and services an uplifting, heart-taking way where I just walk away from the situation. Everything that you have, everything binding, everything you have in your life, and just walk away, and that's shocking for that individual. Where it sinks into his sickness, his way of discretionary. Limitation of actions, disciplinary action, ELC 1.4. Limited licensed legal technician, generally APR 28. Limited practice officers, generally APR 12, and client funds, RPC 1.15a, and foreign law consultants, APR 14, and legal interns, APR 9. In the military forces, of course, the APR 3 and APR 8, the number 8 as in EIGHT 8, and that's admissions to practice. And that motion, admissions to practice, APR 3, and disciplinary action, this index, and the format and paper, GR14. Now the G20, the summits, the G20s, those are green, but now they're yellow. But the G Summit 20s are green. And those greens were served right at Miller's office, 712 Okanagan Place, 7 days a week at that time. See, back then, back then, there's done the snow, the rain, the sleet, the waves, natural disasters. It's still handing it to you. The name changed, and that's the name change. Attorney notice, APR 13. Firm names and designees, RPC identities, and family-owned businesses, just different Denny's, same owner. Names changed, attorneys notice, APR 13, and firm names as designees, RPC 7.5. The objections to disciplinary action are review, ELC 5.6. An oral argument disciplinary action disciplinary board, ELC 11.12. The overdraft client found trust accounts notification, ELC 15.4. The panel's disciplinary recollection report, which is called the selection panel. It used to be the recollection report long time ago. You come in and serve back then that cemetery, George Washington Cemetery, used to be tumbleweeds, used to be weeds, it used to be irrigation. Used to take a water hose around and irrigate the land. Long, but before it wasn't a hose, it used to be irrigation lines. It used to be carry on metal kind of a pioneer wagon, like George, long time, your little wagon with ponies, some horses, some 20 hands, 25 hands, some stormy horses, some, of course, Indian horses. Took it away from the Indians because you kill all the Indians. You have all these horses now because the Indians are dead. So you have wagon wheel, and you got these horses, and you got this tumbleweeds, and you got this man-made kind of. You got to have your horse plow and overturn the soil to put somebody in the ground. Miller's administration, George Washington administration's office back then. All the headstones, all the native islands, generals, increments, first and siblings. You got these Jews and siblings and Germans and intermixed. You got all these individual confiscated parties and services, investing in their service. Okay, so this is overdrafts, client fund trust account notification, ELC 15.4. Panel disciplinary selection panel, ELC 2.2. Personal property, closing limiting practice office, APR 12. Petition disciplinary actions of an index, Pleading format paper, ground rule 14. Judgment of disciplinary actions, applicants of law, ELC 10.10. Paper and format, GR 14. Signature of attorney, APR 13. Practice of law board, generally GR 25. Privilege and immunities, disciplinary actions, this index. Lawyers and assistant program, APR 19. Lawyers funds for client protection, APR 15. State Bar Association, this index. Pro bono, generally RPC 6.1 ET sequence. Emergency APR 27 RPC and 5.5. Pro Havoc Vice, that's Pro PR, like Microsoft Community Services Pro. Hack, HAC, like sucking all the sewer lines, all congested system and cleaning everybody's valves and sewer lines and put it back into the other one. Use it as water and concentration, like the ships, the water when it full, when it rains, it snows, it collects all this data. It's pro bono, generally RPC 6.1 each sequence, emergency APR 27 RP. Or the Black Hawk, you suck all the Black Hawks. Oh, he does it in seconds and seconds, millions and millions of gallons in seconds. You can imagine the power of this. Pro Hackback APR 18. Pro Safe Friendly Concur House GR 27. Professional Responsibility Attorneys RPC 1.1. Continuing legal education, ethics, and professionals APR 1.2. Prosecutor, powers of duty, RPC 3.8, real property, closing limitation, property offers a part 12, records and recordations and advertising by attorneys, retentions, RPC 7.2. These are increments services where they take their Bible, the left and right hand, a left or right hand, and you put your hand and your announce on RP 7.2. This adult audits, ELC 15.1 ET sequence. Courts, this index. Disciplinary action, this index. Dissemination information, JISCR 15. Electronic document, GR 30. Removal of truancy records, JISCR 18. Telephonic interpret, JR 11.3. Truancy records removal, JISCR 18. Regulation, continuing legal education, follow APR 11.7. And also reports and continuing education, attorney compliance and sponsor reports, APR 11.6. Judges, GR 26. Disciplinary action self-reporting, ELC 9.2. Reports, continue, judges, this index. Lawyers fund for client protection, APR 15. Request for admission, disciplinary action, ELC 10.11. Restitution attorney, and that's a restitution attorney clients protection fund, APR 15. Review, appeal the review, generally this index. Right to counsel, disciplinary actions, this index. Rules of court, classification, GR1. Rulemaking, GR9. Saturday, courts closed, GR2 closed. Filing document extensions and time, GR3. And those filing document extensions are GR3. Seals, court records, GR15. Family law courts, GR22. And again, this supersedes in these services for the increments for rehearing disposition motions. This does the rule amendment of formal complaints and services for Rule 1.0.8 motions. Also the right to amend, make amendment service because of the so many services that were answered on disciplinary counsel services, amendments, and formal complaints, since respondents are provided on 4.1 needed for the nerve and the serve of this notice. The answer of the amendment of Rule 10.5 governs the answer to amend, except the part of verbs and these prod verbs and proverbs and verbs, adjective verbs, action verbs, services. I mean the description adjectives is because answer on it. It means positive or negative or increments in that positive factor may reincorporate and reappearance and adopt effective October 1st, 2002. Now, the service of papers, increments on Title IV, generally appropriate rules. These are service of papers, pleading the paper related to discovery with a written request on the motion for which be heard by ex parte in every similar party document issued in the Supreme Counsel respondent lawyer. Under those rules must be served as opposing party. In the hearing and pending hearing officer or designee for the exception of the accuser. See, anybody of the accuser must stand up and confront the individual consequences because of the judge and increments of the paper. Increments of all judges and increments have been sworn on all authority by Barela because the file of the declaration questionnaire is certified compliance with the paper itself. And this beautiful piece of paper, very much beautiful piece of paper. It has the RPC, means of professional conduct, adopted by Washington Court. He has the APR, means of admission of practice rules, has the CR, means the Superior Court civil rules. The RAP, means rules of appellate procedure. There are PC, mean rules of professional conduct adopted by the Washington Supreme Court. And also has the panel, means of hearing the panel under Rule 10.2A2. And also the party, means of disciplinary counsel of respondent except Rule 2.3H and 2.6E, party of includes of grievance. M, respondent, means lawyer against whom a grievance filed of lawyer investigating disciplinary counsel. N, APR, means the admission of practice rules. And CR means the Superior Court civil rights, civil rules. And RAP means the rules of appellate procedure. And RPC means rules of professional conduct adopted by Washington Supreme Court. And the words of authority means the direction or the right up to or permitted to. And must means required to in a positive way, not in a negative way. The positive way means in a slope, curvy, processing moment, the increments that we set. And this means should, means recommending, requiring. That means on the calculus or the accounting, astrophysics or the physics books as an inquiry for the questionnaire when it says as should or mean as or of or a increment of minus or negative or plus or a increment of incentive means positive. Or this rule 2.3H and 2.7 has a meaning of a co-judicial component means B. And it goes in B. But it doesn't tell you B. It says 1.2. Meaning ascribed rules of appellate procedure adopted October 1st, 2002. Libra. Not Scorpio, not Aries, not Ram. Like rams ramming you in the head and being territorial. And you have to pick them up by their puny testicles or vagina and escort them and pick them up and like lamps and crane, put them down gently into an environment where they're will be taken care of in some kind of way, shape, or form, just away from me. See, it says this should mean, ascribe means required to. It means Title 23H, 26 should has meaning ascribed the Code of Judicial Conduct. Meaning ascribed to the rules of appellate procedure adopted, and meaning ascribed the rules of appellate procedure. See, rams just ram into you until they're unconscious or tired and you fall over asleep until they stop ramming in the head. It gets kind of old. So when you take like Michael, Lucifer, he has wings. He's God, and he's God's child, and he's a child of God. He's a child in many ways and shape. Because he lives forever, and pretty much he just have these individuals confronting all the time, all the time, over water. And the rules 20.3H and 2.6 should have the meaning ascribed the Code of Judicial Conduct, but 12 should the meaning ascribe the rules of appellate procedure. But unless they clearly indicates otherwise, terms used the rules have following meanings, associating meaning Washington State Bar Association. And the tonic water is one option. The tonic water has some bubbles in it, so the H2O oxygen goes into your flowable, into your brain blood vessels, your red and white cells, and your plasma, and it brings an antibiotic that fights all diseases because you're exposed to these inquiritory individuals. Of course, you have to wear a suit and tie because you have thousands and millions and billions of suits and ties that can be replaced. Class A, it's all good because they're always reaching out for something. The Association Council means counsel for the association for other disciplinary councils. Bar file means pleading, motion, ruling, decision, others, formal papers filed, and proceedings. The board, when used alone, the disciplinary board, the chair, used alone means the chair of the disciplinary board, the clerk, used alone the clerk, disciplinary board. And also disciplinary action means sanctions under 3.1 adoption. And these accommodations, as you would see, would be biscuits and gravy and cereal for the day, and ribeye steak and marinade services for lean meat, lean hamburger, and elk cuisine venison. And also the service was served on a hot grill, dolphin meat. And dolphin meat is also mixed with shrimp, jumbo shrimp, jubilee, and jubilee shrimp with service with dolphin and dolphin service, because you just know you can do when it's caught in the net. But the baby seals will come to you in the service, because you smell the odor of mama and dada, because the service of the ocean, the seas, and overseas, and the airborne service, they smell. The clerk will use alone means the clerk to the disciplinary board. You'll face the board. Disciplinary action is sanctioned under 3.1 adoption, under 3.5. Final, the means of review have been sought in timely fashion. All appeals have been concluded. Now, grievance means person's identity, that entitled identity, the who files the grievance, except confidential source under rule, but the accuser has to step up. Mental and party and respondent, APR, CRR, PRPC, and words of authority apply of all. Because the means of discretionary of the seal, the state seal, the seal that is sealed, it can't be tampered with or fabricated, attached, fabricated lies and service, because this is evident. The party means the disciplinary counsel or respondent, except rules 2.3H and 2.6D. Party includes a agreement, and respondent means lawyer against whom the agreement is appealed, or lawyer against investigator, the disciplinary counselor, the accuser. APR means the admission rules. CR means the Supreme Court Civil Rights, and RAP means Round Services. These are Board of Governors and Supreme Court organized in structures. These violate some duties imposed by these rules. By RPC 8.4 and 1, so we're under the test rule violating duties imposed in these rules, including limited following duties. Response to inquiries requests about matters investigated is 5.3F and G. File events or foreign complaints by amendment form. The accusers must confront. Comport of discovery and compliance with hearing orders rules 10.11H and 5.5. Attend hearing and bring maturity and the maturity testing, and also blood testing and service requests to the upfront service of the individual, which this is 10.11H 1.5. Attend hearing and bring material requests by District Council Rule 10.3B and C. Responding subpoena compliant order to enforcing subpoena Rule 10.13E, notifying client or liability and Act Rule 4.1, discontinue practice Rule 4.2, file evident compliance Rule 4.3, maintain confidentiality Rule 3.2F, and reporting disciplinary transferring disability and active status in our jurisdiction Rule 9.2A. Incorporated in with the examination books and records rule, of course, in judges' chambers, judges' chapel, and also all the C-17 increments, organic lungums and services and increments in household services, and also the fresh cotton made pulled out of the equipment from the auger. And this is file affidavit compliance rule 14.3, maintain confidentiality rule 3.5F, reporting disciplinary disability and no status. Incorporated with an examination books and records rule 5.2, and notify Office of Counsel and Trust account overdraft rules and 5.4D, binding appropriate rules 3.8, complying conditions simple rule 9.1, and also the pay restitution rule 3.7, or pay cost rule 5.3H or 3.9. Confiscation for the equipment use and equipment, also the services that are used from the services on the Washington Bar Association, and confronts on the rules of professional conduct. Now, the rules of professional conduct is, it's only applying on rules of professional conduct, RPC, and that is the principle of scope, the client relationships, and also the transaction with persons and other clients of the 10,000 increment, processing $10,000 that are in an account for those services. Entitled firms for that association, responsibilities of attorney lawyers, maintaining carrying public service, legal service, direct contact with prospective clients, communication fields and practices, and specialized in firm names and letterheads, political information, obtain government legal engagement and appointments by judges, and also the services sitting in also the quorum with the judges in federal courtrooms, and also the quorums and services 7 days a week. Pretty much because the increments on truthfulness and statements of the others in transaction persons of their clients, the truthfulness on things dealing with unrepresented person, truth in respect of the rights of third persons, of accusers or accusees, and also law firm associates, responsible parties, and memberships of supervised lawyers, and all responsibilities and superseding lawyers, and also restricted right to practice, and responsibility regarding law-related services, misconduct, volume, disbar, and suspend as signing inactive lawyers. And this falls on the rules of general applications on staff. Staff on board jurisdiction administration shall provide administration for the courts. And also the informal admonishment of repairing and pyramiding by the commission. Now you're pyramiding all this factual evidence. An agreement to of the judge and the judgment reprinting considering admission of misconduct by the judge, another judge. So the event of conduct is using it repyramiding, considering event of future complaint, complimenting against the same judge. That good eye, very good eye, very impressive how that went down your esophagus through your jaws into your mouth. Very good eye. Agree of punishment with your silver and golden fork, or platinum, whatever the case might be, to carry on person for this increment, because the punishment of the repayment and agreement of judge, repyramiding this construction factual evidence agreement judge, is meant for the certain prescribed conduct, effective formal endowment and repyramid, and banishment impairment, agreement and informal banishment and repayment. Judge terminates the complaints which rise in punishment repyramiding this faction with necessary referring matter to the Supreme Court. Constitution Article 431, Amendment 71, gives the Supreme Court authority to impose discipline on judges arguable commission and engage in formal discipline without authority from the Supreme Court. The rules delegate small but important part of the Supreme Court discipline power to commission. The commission is empowered to inform, admonish, and remand a judge, or a more serious discipline call for Supreme Court must impose discipline. It requires to consent the judge and judge will thereby waiving the right have discipline imposed only by the Supreme Court. FABA Standard 6.6. The substitute panel, generally the Justice Supreme Court, and substitute recommendation discipline retirement substitute panel for the 9 judges shall be selected provided the rules of judges pro tempore considering commission recommendations. Selection of justice pro tempore considering chief judge and Supreme Court judge appeal that one of the members substitute panel shall at the chief judge pro tempore unless judges disqualify himself or herself otherwise disqualified by section C. So he wants cash, pretty much. He wants cash. He's done 25 years. He's tired of being a lawyer. He's tired of being a judge. And it's about time he's getting tired. I'm watching Felix Barela pulling all these weapons and lodged weapons out of my face, my friends, and bringing the handcuffs and weapons to a bag of evidence and on equipment service. Annie Miller's office laptop. You can browse right there. It says appealing. And this appeal of ours, disqualified panel, completed clerks, sealing, and a lot from the Superior Court judges, full panel, 9 judges temporaries. He disqualifies himself and also disqualified in Section C. Disqualified himself after 25 years. Pretty self-explanatory. The clerk of the Supreme Court shall reflect, she's not the Supreme Court no more, the justice and temporary front from remanding active court appeal judges. Therefore, few of the 9 judges of the Court of Appeals who are disqualified in panels such completed by the clerk selecting lot from the active Superior Court judges and 9 justices and pro tempore the records and disqualifying him and without cause. No judges have served as master member, commission, presenting, otherwise disqualified served, substitute panel. No judge against whom form judgment pending before commission shall serve in panel. Chief pro judge, temporary presiding chief judge, court appeals members of the substitute panel, select of the members serve chief judge pro tempore. Rule 14, several provisions. Server failing the court rule appellate procedure 18 reference service proof of service of failing purpose or unless rules. Computing of the time of rule appellate procedure 18.6 applies computing under these rules. Waiver rights sanctions violation rules rule appellate procedure 18.A D 18.9A applicable procedures under these rules. Alcohol wrap upon Supreme Court rules appellate procedures made appellant and part proceeding following decision retirement judge of grounding by these rules. Confined and privileged communication comes in communication is used to offer peer concerned jurisdiction assistance to any Superior Court Judges Association or District Municipal Court Judges joining in LAP lab. Lawyer Assistant Program of Washington State Bar Association privileged against this disclosure without consent of the judicial officers to the same extent subject to conditions as confidence examination of communication between a client and physiologist. A psychologist in an official way during conflicts of interest because of interest rates and services for the services for that service for that individual for the damages of the mental anguish of the battered woman that she will never be the same again. She will probably not even know her victim that assaulted her because she put her in a coma, right? Let's go all the way into rule bar exam notifications results of the accusers and also the assaulters and the individuals that pretty much took it upon themselves figuring that that guy, what's that kid gonna do? What's that individual right there gonna do without George Washington and Moment in service of what? What's that gonna, is he gonna bar examination you? Is he gonna take you to a bar conduct under a direct board of governor assistance or and that sort of board bar examiner? Is the bar examination shall hold you in February and July of each year and serve such of times a board of governors and deciding commence of times and locations selected board of governors. Rule 4 bar examination notification results. Maybe so. He's going to brush you up on your bars. He's going to examine. Maybe it's noticeable results, but it's called number B. Governor shall cause applicant will notify the results of the examination board. The governor will disclose the result of applicants of the Law School National Conference of Bar Examinations and information divulged and person of applicants concerning them who failed the bar examination, repeating the bar examination. Maybe take you a couple, they'll sink in. Maybe let's give you one more. They'll sink in. We're gonna have this repeated to you. It's called number C, repeating bar exam. Repeating this back to you. This applicant of examiner, the failing of bar examination apply to take to a bar examination. This recommendation admission under admitting practice payment, membership fee, and oath an attorney resident agent that we just brought up in Andy Miller's office. And that's Mr. Mrs. and also the whole conduit and also the uprooted tree that I put in an animal's office, all the increments and necessary evidence for prudent factual information. Recommendation of admission. The Board of Governors shall recommend to the Supreme Court admission rejection of each applicant who has passed bar examination, who is compelled with pre-admission and education requirement for 4 of this rule. Recommendation of admission shall be based upon Board of Governors determination after investigation. But that's not investigation, it's just a word, it's a term, it's a Danny, nothing's changed. Applicant appears a good moral character on respect qualified to engage part in the law. All recommends of the Board of Governors and shall accompanied by them the appliance examining of other documents deemed permitted by the Board of Governors request of the Supreme Court. Recommendation covering documents and papers shall be kept cleared to Supreme Court in separate files. No public record. And pre-admission education requirement by Board of Governors on the before applicant based on bar examination. That's 7 to 10 Washington State Governors and increments on notification of results. As you can see, forfeit the individual route of bearings of the full repeating examination. This recommendation for the missions or order admitting practice, payment, or re-membership fee, and oath and preserve FDIC and direct deposit, and also inquiry, and also the track for deposit inquiries and transmission transactions. Transaction reports, you just buy a total of millions of pounds of gallons of milk for $1, gallons of milk for $1, millions of gallons of water of H2O for water purchase transactions. That's against the law, ain't it? Or is it? It's look on principle education requirement. It says before the applicant has paid a bar examination or qualifies admission without passing a bar examination, be admitted to must complete minimum of 4 hours of education currently under 7% approved by board of governors, occurs if offered by the cost of the applicant. Order of committed practice. Examining the recommendation accompanying the bearing of the papers of transmitting the board of governors, the Supreme Court of entering some order each case deemed admissible. For the applicants to deem qualified Supreme Court entering the order admitting to the practice of law conditioned upon such applicants. And they have taking the filing clerk Supreme Court oath attorney within 1 year for the date of bar examination results made public except for the good cause shown, paying the bar examination membership fee for the current year, signing residency of the agent agreed to do the section. The oath attorney must take before elected appointed judge, including judges. So removing all those rocks and the sod and soil and services and the D9, D6 and Bobcat and Turbo and also the ANCRES baseball, basketball, and also the post office service in the federal building and also the Washington State federal building and all the agencies, depending on administration, depending on administrative overhauls, all those increments on your order of practice. So now you have to concentrate on the flag etiquette of all the services on pointing the bearing and pointing trajectory from the stratosphere into your womb that's parked into the Tri-City Herald. That, as you can see, how it sits there, and how can a baby child weigh 100 pounds with all that intestine around its neck came from that tree like that? Can you give me a bearing on that, admitting the practice of that examination of the recommendation accompanied by that papers and transmitting the board governing Supreme Court and enough in order such as a deem admissible for the applicants of the deemed qualified Supreme Court entering the order admitting from the practice of law conditioned upon the applicants taking the filing clerk Supreme Court oath attorney within 1 year, the date of bar exam result made public. So age 1. So age 1 after 1, it would be accept the cause of showing paying the bar examination membership fee in the current year of that age 1. The designated resident agent is required to do so section E. Now, the oath of an attorney. The oath of an attorney must be there to be a lawyer or in that area. You're 100 pound, being 100 pound with that intestine being around your esophagus of your throat and your neck and the bearing of your whole body. This must be a nuisance because the event of society applicant outside the Washington State Chief Justice Department society impossible and improbable for the silverback gorilla across from Tri-City Herald. There's a silverback gorilla statue, kind of a cigarette across from the Tri-City Herald. The nuisance of the individual hair. Electing the appointed judge and Chief Justice upon the proper application of the circumstances designee authorized by law administrative oath before whom applicable appear. There's a chicken farm coop approximately 23 feet away. So you crawl from that age, from that distance, from that you probably jump into the, there's a chicken coop there. Applicant may appear to take the said oath from all those steamed, spoiled, and wrapped eggs in concurrence for that sentence for oath of attorney for all their services. So the state of Washington County of that during time and period is solely declared and fully subject to laws. And their services they can condemn, and their services of the United States of America will abide by the same. Number 2, support constitute the statute of Washington State Constitution of the United States and the rules of professional conduct approved of the Supreme Court of the state of Washington. Number 4, increments are not in number attached to number 3. I will maintain and respect the due of the courts of the justice judicial officers. Number 5, will not counsel or maintain any suit or proceeding which an appear to unjust or any defect except believe honestly datable in the database, of course, undoubtedly an intangible evidence, that occurred which is truthfully intangible evidence and furnishing really nothing but factual information, which is fully a subject of law of the United States here in Washington State, laws of the United States, and will be abided by the same. And you will support the Constitution of the States of Washington, the United States, and the rules and the professional conduct approved in the Supreme Court in the state of Washington, which is attached to the maintain respect of the courts and jurisdiction courts, and students will maintain any suit and proceeding shall appear. And continue on with number 6. Will maintain confidence, preserve evidence and secrets of the clients, and accept on the compensation in connection with the business of the client unless compensation from with and all his approval of the client with approval of the courts. And then abstract unsafe personality with advance and faction proves it honor repetition on part of witnesses unless in which local justice of cause of which it be charged. And number 8, a factual, it is sworn on sobriety is sworn before the day, and right above is entitled 8. Never reject for consideration person himself by causing definiteness and unpressed and delay unjustly cause of any person. Now describe and sworn before this day. The judge, non-resident lawyer's resident agent. So, requirement of a member of Bar Association resident, a bona fide resident, state of Washington, every active member of a Bar Association does live and maintain an office in the state of Washington shall file the Bar Association name, address of agent, the state of the purpose of receiving the service of the document required permits of the state courts of reserved and derived and resident lawyer service delivery on such a greater and deemed to upon delivery of the lawyer. Amendment effective July 9, 1960, March 10, 1971, April 26, 1974, May 4th, 1980, September 1st, 1984, October 11, 1985, January 25th, 2002, June 1st, 2006, January 8, 2013.
Hey guys.
You decided to come in today?
My choice.
Has
it just been dead?
Oh, yeah.
Now, the
You're not going to,
Almost Consolidated Appropriation Act is a legal immigrants reform. Legal Immigrants Reform Responsibility Act 1996 was considering sentencing guidelines in the general statute of limitations, Washington State Court orders, Washington State orders, federal guidelines, state patrol services as services and increments of their best inquiries of penetration and using this fabric material as their and belong to them and using it as any manipulating ways in imposing sentence and services and increments as you can see is pretty self-explanatory. The sentence guidelines pursued under Section 94P, Title 28, United States Code, United States Sentence Commission, saw permanently sentencing guidelines, amending sentence guidelines, and offender and convicted or offender related to smuggling, transporting, harboring, or excluding aliens in violation of Section 274A1A, Immigration National Acts of USC 1324A1A 2B, in accordance with subsections. And the Promoting International Terrorism Acts, there is Title 120004, September 13, 1984. Same guideline increased for terrorist crimes. United States Commission is directed and sentencing guidelines to provide appropriate enhancements for these services involving primary international terrorism, such as involvement intense with self and elements of crimes and services and parties or perhaps accusers or falsifying documentation that's presumably pretty much factual evidence. Says they have accounting offices that do this, and the accounting offices on increments for the CASAS or ASVAB or the SAT test, which is 2,400 points maximum. The maximum point is 2,400 points. General Accounting Office says it impacts operations and guidelines submits on this. Anybody on that computer mainframe system doing this 2,400 point test is on a General Accounting Study Impact database. This database retrieves all information for regulations increments and driver's license increments. The age of 15, when you're driving around age 15, 15 and a half, Anybody with an MIP, MIC at the time being in violation before they're 18 shows on their ASVAB abstract record, shows on a CASAS test, an SA test when you test 2400. They make sure you test 2400. They make you do testing and retesting by hand, by knowledge, by calling, by prudent information, witnesses, any testimony of service, any law, judge, surgeon general, watching your testing, making sure you're not cheating in shape and form, because their credibility in forms and your file formats, if they're coming a record, non-autonomous record, because of their factual office studying, their impact of operations sensing guidelines, subject procedure are established by 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, all the way to 22, Title 22. So the Title 23, October 12, 1984, 98 Stat 20330 provided A1, 4 years after same guidelines promote Section 94A1 provision of Section 3581.3583, Section 362, Title 18 United States Code, go in the fact General Accounting Office undertake to study the guidelines in order to determine an impact to make sure they didn't cheat or have witnesses testifying if you cheat or not, if you use a pencil or pen or any kind of instrument of using calculating, because you can't use a calculator in any shape or way or form. So the services they have is called the established policy, promulgating such rules, regulations, and commission as necessary to carry out the purpose of this chapter. Appointing, number 2. To fix the salary and duties of the staff, directors, and commission, whose self-serving discretion commission shall compensate the rates and exceed the highest rates of hereafter prescribed in Level 6 and Senior Executive Service Schedule 5 U.S.C. 5382. Number 3, denying revised right of ANCRES regular supplemental deficiency appropriation prior to any submission. Such request office management budget by chair. Number 4, procuring commission temporary increment service to the same extent authority by Section 3109B in Title 59 States Code. Number 5, allies and commit the service equipment, personal equipment, and facility equipment, federal, state, and local and private agencies, instrument equipment, such reimbursement and therefore after. Number 6, without regard and 30, you don't have to cash that. You take that check to Andy Miller's office with the agent service and tear it up and leave it there, or just leave it all the information there and have it served to an individual services in front hole. And that is the whole Andy Miller at CO Benton, Washington, 509-73535, fax 509-736-3066. That's the facilities, federal, state, and local private agencies and instruments with the reimbursement thereafter. Without regard, 31 U.S.C. 3324, enter into the perform such contract, leases, comparative agreements, other transactions necessary to conduct functions, commissions, and public agencies and persons and firm associates, corporates, educational institutes, and nonprofit organizations. Number 7, which accept, employ, and carrying out the privileges entitled voluntary commencements and services notwithstanding provisions 31 U.S.C. 1342. However, individual providing services shall consider federal employees representing Chapter 81, Title 5, United States Code with respect to job and current disability, and Title 28, that service concurrent with the United States Code in respect to the tort claims. Tort claims are civil. Civil claims are tort. Tort are just walk-ins and discretionary, as you can see on the right bottom half of the Washington Bar Association. Signatures, delay review, and also the multiple sentence imprisonments, and also the factors of consideration imposing concurrent and consecutive sentences. Treatments of multiple sentences, aggravated and not. Non-violent and violent services, as you can see. But intermex, they will commence of sentences and credits prior custodies, and also the results of offenses, and also the charge for their defendants, arrested, commissions, or accusers, or accusees, or defendants, or victims, and there are no parties restitutions as a part of the recommendations as it poses. Number 8, request for such information, data, reports from federal agencies, judicial offers as commissions from the time require any reproduction consistent with others, monitoring performance and all the services, instruction on the services. These services there don't even apply. These do not apply at all. They're self-explanatory. These information affidavits. This is a rule of transmittance, jury questionnaires, and clerks and papers and capital cases. These are questionnaires used during jury selection, clerk trial collection, sealed transmitted copy, and all questionnaires Supreme Court along all Supreme paperwork, including copies and clerk minutes. Clerk of Supreme Court's bribed and appellate counsel, prosecuting attorney. Copies of jury questionnaires, such as copies that remain in possession of counsels, are not made available to the defendant. Preparation for report proceedings of capital cases. The clerk of trial court shall prepare a list of pre-trial hearings. Post-trial hearings include camera, ex parte proceedings, data, and hearing the name of court reporter, the accuser. The last and served by the clerk in trial of each court reporter and the prosecuting attorney, defendant in trial, and the appellate counsel in trial within 10 days of entry of judgment and sentences. If appellate counsel has been appointed by representing defendant in that list, the first prepared and clerk trial court have sent copy of the list to each appellate counsel 10 days by appointment. Any point served file objections to proposed amendments on the list within 10 days. After recipient preparation, clerks in trial court, objection amendments have served and filed objections. Proposed amendments must be heard by trial courts for settlements and approval. Judgment of proceedings are held in reason, unable to permit settle questions under the judge, and act place of judge before whom proceedings were held. Now, number C. Concurrence after B in the consecutive concurrent sentences, or whatever the case might be, and flow and presumption, and falling in within that 365-day sentence, and the physical years 365 and a half days. That increments of the 30 cents to the dollar, which is 70 cents that's taken from that dollar. So this number C, once this hearing settled here at trial court, serve the copy each property reported and file the copy of Supreme Court. The final indicates the date and Supreme Court's reporter's financial agreement, which have been made payment of transaction costs. The court report shall complete report considering 90 days after reporting. The list of hearing reporting proceedings cannot be completed within the time. This court reporter shall, no later than 10 days before due date, submit an affidavit prosecuting attorney, that's Andy Miller, process 712-179, place the defense and reply attorney Supreme Court, standing in reason delay, any party in court in support, and this is CUNIT, C-U-N-N-I-T, whatever the case might be in FABs and sentence guidelines, services, and also concurrent consecutive sentences, and then also 25 to life, and imposing and repeal of services, CUNIT, C-U-N-N, and 712L, CUNIT, and also these basins. Tangible factual evidence is a party of the party reporter, accuser, cruiser, defendants, victims, and institution, or hearing any expressionary expunging in any contempt and way of factual extensions. And that's the phone, any wireless service, I3, A5, I3, I5, I7, I8, Sedgwick's 10, 11s, and Apples, and the service devices. There's extension of time from the landline or Supreme Court service. Number E falls in E. The court report file report proceeding with clerk of trial court shall transmit report proceeding Supreme Court. The clerk Supreme Court shall provide a copy of report proceedings to the defendant, 2 copies of the report proceeding the defendant, presumed attorney, copy of the sealed document that is sealed, not touchable, can't make things up or attach it, discard it, or erase it, and turn it, get rid of it, any way, shape, and form. Objections, amendments of the report proceedings served and filed within 30 days. Party receives copy of the report proceeding and copies of opposition, which be your objection, shall be filed with the Supreme Court, and then the shall settle the report proceeding in accordance by RAP 9.5C and D. Briefing schedules shall be suspended until the record is settled. Record may occur supplemented at the time of accordance, RAP 9.10, and transmittal jury, what preparation records, and also the post-sentence petitions. Certification of ordinating, where original, where a located in the services, the occurrence of the courtroom, and also the polis, which is the podium, and also the gavel and robe, and the occurrence for the seating and jury, and the services for personal Rule 6.6 questions certified by a federal court. Generally, Supreme Court returning and intern and petition and determined question law certified to under federal court local law certification procedure act question state law which has been clearly determined does involve question determined interference in the United States. Constitution certificate procedure and means which of the federal court submits Washington State Supreme Court. The rule provides is pursuing the procedure implementing RCW 2.6. Caution plead brief filed Supreme Court. Caption of the case should be certification from Oregon United States Court, filing cause, index, and number in the same manner appealed to the Supreme Court. Court record shall certified by the federal court required by statute. Procedure of federal courts, and then shall designee and designate who will fill the first brief. The first brief should be filed within 3 days after the record filed in the Supreme Court. The opposing part should file opposing brief within 20 days. After receipt and an opening brief, applying the brief shall be filed within 10 days after the opposing brief is served. Brief should be reserved according to the Rule 10.2. Time filing and recording assembly required in the brief may be extended of force. For reproduction of brief should form provide the Rule 10.3, 10.4 briefs of reproduction clerk in accordance with the Rule 10.5. Costs, provisions, Title 414, application exempt. Look, cable except both parties. Don't watch TV, you don't use the radio, you don't use MP3, MP5, any CDs, DVDs, VHS, and you don't have any definitely renting or loaning, but you do rent land and substitute statements and receipt transactions for the occurrence for the UBI number, running a business and services, and you do not partake or purchase or imitate, but individual fabricate or manipulate or designee or fabricate or falsify document or misuse or railroad the community and services for their increments for their briefings. This is brief E. Federal court shall designee file first brief. Brief should be filed within 30 days. Recorded file Supreme Court. Opposing part should file opposing brief 20 days. Except receipt opposing brief. Reply brief should file 10 days after opposing brief. Brief should be served in accordance with 10.2. Time filing recorded supplement recorded or brief by may be extended, of course, of the cause, of the extended cause. This is all facts and true non-fiction when you put in service. Because 16.7, other rules of applicables, Rule 1.1, 1.2, 18.1, 18.3, 18.10, and 18.21, 18.24 are applicable. Special proceedings as the title. These post-sentence petitions generally department and these services with occurrence and service are paid back on full increments, and then they wash their titles and hands of them. Increments for these increment passing information, miss havoc and misportraying individuals in contact, leaving the house or taking vacations, increments fabricating individual lies and testimony and services, increments in blindsiding, deciding services increments because the individual processing information, litigating the system, or misusing system for interposit inquiries and increments. These sanctions and remedies falls on Title 13, Sanction Remedies, or 13.1, Sanction Remedies. Upon finding lawyers was committed an act of misconduct or more of following may be imposed: sanctions, disbarment, suspension under Rule 13.3, re-impairment and amendment, and under 13.5 remedies, restitution, probation, limitation, practice requirements, lawyers, and continuing legal education courses, estimates, and costs. Other requirements consist in purpose and lawyers and discipline. Rule 13.2, effective day of suspensions and disbarments. Text rule, effective rule. Do not use tech, don't use landline, we use landline, use services, but definitely don't use texting information among services, direct, in person also, over conference services, increments for the seating, increments for the effective Facebook, YouTube service, or whatever, increments for the i3, i5, a8, generation 10, 11, Microsoft component, Microsoft Windows 10, the suspension department is effective of the Supreme Court's order, which will be only 7 days after the date of order. No date says superseding disbarment effective date, court order. Effective date, suspension, disbarments. Rule 3.3, suspension, term suspension. Suspension must be fixed period time extended years. Reinstatement after period suspension associated with suspend the lawyer to the respondent. Law firm administration, law bar, Washington Bar Association, Andy Miller's office, 712 Connaught. Any post stays in 20 to life, no sentences, Connaught. Post state life services, 712 Okanagan Place. Lake County service, which is the satellite system, is RDK System Stellar Systems, and that's John Deere, Moline, Illinois, and the Microsoft components and Windows services, and Augur command units, and RTK 9560 RT tank systems and integrated systems, 0 to 35 miles an hour, versus an Abram tank with 2 jet engines, 0 to 65 miles an hour. The Trex, which is the most component software tank upgrade system for the microcomputers for the Abram tank to jet engine thing, for the 0 to 35 miles and 0 to 65 miles, 0 to the compound interest into these rules and remedies of the sanctions and debarments and remedies, restitution, and probation limitation practice, recurrence law and intent, and legal education course assessment cost. Rule 13.5 and 13.3, repairing factual evidence, which is repairment. This is notice of repairment or imposing repairing physical association counsel prepares a notice of repair consisting order imposing repair together hearing officer finding conclusions, recommendations, opinions under the board and the court stipulations and discerning of final decisions in the course of basis order imposing repairing together, and also covering and notice impaired what the clerk is serving respondent declares, and under Rule 4.2b, form of no. This is notice of repair in most of substantial following forms. Notice of reprinted lawyer, Washington Bar Association bar number, has been ordered and remarried in following attached documents, title, date, attached documents, and this is effective October 1st, 2000, effective September 2005, January 1st, 2014. These are lawyer of conduct, and also discerning of cumulative dominations. These are factual and effective, including amendments that are established on the Washington Rules of Evidence. This is the document that can be factory, what state seal on, it can be changed, borrowed, or fabricated in any way, shape, and form in the state of society, population, Mr. Donald Trump's signature, Annie Mills' signature, Ivanka Barela statement consideration for the divorce, and you are divorced in the single sex manager, Donald Trump. Pictures of Roberta Barela, wrong administration office, first in class, and also the last class, first class, and Mrs. Lola Hernandez hitting Mr. Donald Trump with a cane. Mr. Snoop Dogg hit with a cane, Mr. Senator McCain and Annie Miller and Mr. Soderman, and that's Sackman Services, and they're pulling a cane right off her disposed vows. He's dead now, and that's Eazy and NWA Services at Oakland, California, and also services here in San Luis Obispo and Yakima, Washington. Yakima chief in place, places Lola Hernandez places the administration Indian tribe under detaining arrest in front of every inside community services. This ballot form and Donald Trump's signature and first name Annie Miller's signature, and also the check issued out and Jane Mueller administration issued out to Felix Barela. And first name, last name, and concurrence, the services on election services and campaigning, the transaction reports and the manufacturer abstract record services, and Kimber says it's not tangible and made up in any shape or form. You can't, the state seal is pretty much, you can't change this and make things up in the situation of assaulting and dragging him out into a sidewalk or off the sidewalk, distracting him in the way, or running him with a vehicle or truck at Bravo and Services. This is pretty much self-explanatory. Not violent in any way, shape, and form, and definitely the services are even don't even belong in first and last name. It's pretty, this is Washington State Court rules, federal guidelines, increments on the services on appeal. The fabricated latch Washington Bar Association, which is the latch and information is unlatched for considerations on appeal. This is October 2019, September 2019 at in Othello, Washington at 610 Eric D. Olson. Under services is also Ms. Kim Williams, Secretary of State, which is upstairs. She had surgery. pain and anguish and the services they have in ANCRES. Anyways, the surgery are going to be done on the Maxilon here in Mr. Crawford office, and also in Mr. Office, and reflect on the Manalog information on the download summary. So they only belong to him. This is February 18th, February 4th, 2020, March 3rd, 2020, and the tampered information. This is December 3rd, 2018, September 27th, 2019, and this is March. This is April 9th, Thursday, 1:46 p.m. Andy Miller's office.